A company may have money, assets, employees, and investors, but one wrong decision by a director can destroy everything. So, what duties does the law impose on directors? Can directors act for personal benefit? Can they misuse company power? And what happens if they violate their responsibilities? That is exactly where Section 166 of the Companies Act 2013 becomes important. Introduction to Section 166. Section 166 defines the duties of directors. This section creates ethical, legal, and governance standards for company management. Directors are not owners of company property. They are fiduciaries entrusted with responsibility, power, and accountability. The law expects honesty, integrity, and responsible conduct from directors. Duty to act according to articles. The first duty under Section 166 is duty to act according to Articles of Association. A director must follow the internal constitution of the company. The articles define powers, procedures, and governance rules. Directors cannot ignore these provisions or act beyond company authority. Why articles are important? Articles of association are binding on directors. They regulate management powers, voting authority, delegation, and decision making. If directors violate articles, their actions may become invalid or challengeable. Therefore, directors must understand company constitution before taking decisions. Duty to act in good faith. The second major duty is acting in good faith. A director must act honestly, sincerely, and loyally. The focus should always remain company welfare, not personal benefit or hidden motives. Good faith is one of the most important principles in corporate governance. Stakeholder approach under Section 166. Section 166 adopts a modern stakeholder model. Directors must consider interests not only of shareholders but also employees, community, and environment. This reflects modern ESG governance principles. The law expects socially responsible decision making. Duty of care, skill, and diligence. Directors must exercise reasonable care, skill, and diligence. Serious. They cannot blindly approve decisions without understanding consequences. Every director must actively participate in governance and supervision. Higher expertise means higher responsibility. Experienced directors are expected to exercise greater caution and judgment. Independent judgment. The law also requires independent judgment. Directors cannot simply follow management blindly. They must think objectively, question proposals, and analyze risks independently. Independent judgment protects the company from poor governance and manipulation. Duty to avoid conflict of interest. One of the strictest duties under Section 166 is avoiding conflict of interest. A director must not place personal interest against company interest. Even possibility of conflict can become problematic. Transparency and fairness are essential in management decisions. Examples of conflict of interest. Suppose a director awards company contract to his own business secretly, or influences decisions benefiting relatives or associates. This creates conflict of interest. Such conduct violates fiduciary duty under Section 166. No undue gain or advantage. Section 166 strictly prohibits undue gain or advantage. A director cannot misuse position for personal profit. The restriction applies not only to the director but also relatives, partners, and associates. This provision prevents abuse of corporate power. Refund of undue gain. If any undue gain arises, serious, the director must refund the amount to the company. Even indirect benefit may require repayment, stern. The law follows strict governance standards. There is no defense that amount was small or insignificant. No assignment of office. A director's office is personal in nature. It cannot be transferred or assigned like property. Any attempt to transfer directorship to another person becomes void. This is because appointment of director depends on trust, confidence, and personal capability. Penalty under Section 166. Violation of duties under Section 166 may attract penalty. Fine may range from 1 lakh rupees to 5 lakh rupees. This demonstrates seriousness of fiduciary obligations under company law. Fiduciary position of directors. The core concept behind Section 166 is fiduciary relationship. Directors act as trustees of company interests. They control company resources on behalf of shareholders and stakeholders. Therefore, honesty, loyalty, and integrity are legally expected from them. Good faith explained. Good faith means honest intention without hidden motive. A director should not manipulate decisions for personal advantage. Every decision must aim at promoting company objectives and long-term welfare. This principle forms foundation of ethical governance. Standard of care. Section 166 follows both objective and subjective standards of care. Objective means conduct expected from reasonable director. Subjective means considering personal expertise and qualifications. A finance expert director may be expected to apply higher financial diligence. Modern corporate governance. Section 166 reflects evolution of corporate governance in India. Earlier, company law focused mainly on shareholders. Modern law includes employees, society, and environmental considerations. This demonstrates shift toward responsible and sustainable governance. Practical example 1. Suppose Mr. Prasad Khopkar rejects a risky expansion proposal to protect company stability. This shows good faith and responsible governance. The director acts in company interest rather than personal ambition. Practical example 2. Suppose a director secretly approves contract to his own company without proper disclosure. This creates conflict of interest and violates Section 166. The director may face legal consequences. Practical example 3. Suppose a director secretly earns commission from company suppliers. This becomes undue gain. The amount must be refunded to the company, and penalty may also apply. Practical example 4. Suppose a director signs financial statements without reading or verifying them. This demonstrates lack of diligence and care. Directors cannot escape responsibility by claiming ignorance. Practical example 5. Suppose a director transfers his office to a friend through private agreement. Such assignment becomes void under Section 166. Directorship cannot be transferred like personal property. Practical example 6. Suppose management proposes suspicious investment decision. A director questions the proposal and demands clarification. This demonstrates independent judgment and proper governance conduct. Why Section 166 is important? Section 166 creates ethical framework for company management. Without fiduciary duties, directors may misuse power for personal benefit. The law therefore imposes accountability, transparency, and governance discipline. Strong director duties create stronger companies. Governance objective. The objective of Section 166 is protection of stakeholders. Investors, employees, creditors, society, and environment all depend on responsible governance. Directors hold enormous decision-making power. Therefore, Law imposes equally strong responsibilities. Exam Golden Line. Remember the core duties under Section 166 clearly. Act according to articles, act in good faith, exercise due care, skill, and diligence, avoid conflict of interest, avoid undue gain, and never assign office. These are the foundation principles of director duties. Memory trick. Use this easy revision formula. Good faith, care, and skill. No conflict, no gain, no transfer. This captures the entire framework of Section 166. Exam trap alert. Students often make important mistakes under Section 166. First, they forget environment and community are also protected stakeholders. Second, they think only direct gain matters. Wrong, because even indirect gain must be refunded. Third, they think only actual conflict matters. Wrong, because even potential conflict is risky. And fourth, they forget assignment of office is always void. Memory trick. Use this easy revision formula. Good faith, care, and skill. No conflict, no gain, no transfer. This captures the entire framework of Section 166. Section 166 transforms directors from mere managers into responsible fiduciaries. The law expects ethics, accountability, and integrity from every director. Because companies influence investors, employees, society, and the economy. And strong governance begins with responsible directors. That is the true purpose of Section 166 of the Companies Act 2013.